topic, but it's been very interesting and encouraging to learn over the last year or so that what a year ago was an issue that a lot of people didn't care about, or a lot of people didn't even know what you meant when you said the word gerrymandering, has mushroomed into something that so many people care about, so many people are willing to share their evening with us to talk about this issue. So thank you all for coming out tonight and for being involved in this issue. I just first want to introduce the Public Interest Law Center. We're a nonprofit law firm in Philadelphia. We've been around since 1969, and we use high-impact legal strategies to advance the civil, social, and economic rights of communities in the Philadelphia region and across the state of Pennsylvania who face discrimination, inequality, and poverty. And we do this through litigation, community education, advocacy, and organizing. We're a nonpartisan organization. As the Senator mentioned, even though this, in Pennsylvania, there's a certain partisan slant to what's going on here, the shoe is on the other foot in some other states. And so this is an issue that really affects both parties when you look at the country as a whole. And I'll also just mention that the Public Interest Law Center has a long history in working in the area of voting rights. In the earlier part of this decade, we represented Amanda Holt. Amanda Holt at the time was a 29-year-old piano teacher in Allentown, Pennsylvania, who was surprised to discover that her friend who lived just down the street from her lived in a different state house district. She wondered how that worked. She bought some software, she got a little more into it, she drew some maps that looked a lot just more logical than the new maps for the state house and state senate districts that had come out of Harrisburg. And she asked, you know, why can't we have a map like this instead? And we were able to represent her, take it up to the Pennsylvania Supreme Court, which actually threw out the maps, the original maps that were drawn for the state house and the state senate in Pennsylvania, and replaced them with maps that are significantly better, although, as you're hearing today, still have a long, long way to go. We also represented Vivian Applewhite and a number of other individuals, along with the ACLU Advancement Project and Arnold Reporter in the voter ID case in Pennsylvania. In 2012, as many of you remember, Pennsylvania, the legislature passed and Governor Corbett signed the most restrictive law in the country, which would have forbidden people to vote any longer if they didn't have a photo ID card and show it at every election. We won that case, and that has helped hundreds of thousands of people retain their franchise in Pennsylvania. So Senator Leach mentioned Governor Gerry of Massachusetts taking you back 200 years. I want to take you back a little farther, back to the 13th century, which is really where this story begins. In the 13th century, there was this sort of informal pattern emerging of various jurisdictions, various counties or earldoms or what have you within England getting representatives in the House of Commons. And in the 13th century, two members of Parliament were assigned to the county of Lancashire, and two members of Parliament were assigned to a place called Old Sarum. They didn't change it for a while. And in fact, by the 19th century, by the early 19th century, you had the Industrial Revolution, you had the city of Manchester growing from nothing to being one of the great cities of Europe in Lancashire in a very short period of time, and they still had only two representatives in Parliament, even though it was I think, at that point, the third largest city in England. Old Sarum's population shrunk and shrunk and shrunk, and in fact for a very long time was zero. No one lived there anymore. The family that owned the land, though, still got to vote in the parliamentary elections there. So there was just one small noble family there, the Pitts, including like Prime Minister Pitt, the elder and the younger, and they controlled the two votes of Old Sarum. So this wasn't changed until 1832. So for almost 500 years in this part of England, you had no reapportionment. They never redistricted at all. There was no map making, and that's also a problem. This happened in the U.S. South as well. It happened all over the U.S., but it was particularly problematic in the South. That decade after decade would go by, census after census would happen, and no one would redraw the maps. And people tried to challenge this in federal court, and the courts kept saying, we're not going to touch this. It's too political. Only politicians should decide these things. We're staying out of this one. That changed in 1962 under the Warren Court with a landmark decision out of Tennessee, Baker versus Carr. And that was the first case where the U.S. Supreme Court said, actually, there is a role here for the federal courts because the federal Constitution guarantees equal protection of the laws. And when a state has one district that's so much bigger than this district over here, that means that the people in the smaller district have a bigger voice. Each person has a vote that counts a lot more than the people in the districts that have grown. And then in 1964, the Supreme Court handed down a pair of cases, Westbury versus Sanders out of Georgia and Reynolds v. Sims out of Alabama, where the court actually put some teeth into that and struck down state districting plans and said, no, you guys have to draw the maps again in light of the new census data and make sure that you have one person, one vote in your state legislative districts and in your congressional districts. So that's really the ancient history of that, and that is important to understand when we talk about how we got where we are today. So what are the rules that govern how these districts should look? I think Carol is going to talk a little bit about the process and how, who makes the decisions. But I just wanted to briefly mention the, if I'm wrong, I can talk about it now. The Pennsylvania Constitution sets certain standards for state Senate and state House districts. They have to be compact, they have to be contiguous, they have to have equal population, and the Constitution says, unless absolutely necessary, no county, city, town, borough, township, or ward shall be divided. So that's what the whole case was about. I mentioned this piano teacher from Allentown. When we filed that case, Amanda Holt was able to show, well, there's actually a great way you could draw a map and satisfy all those other requirements and split up far, far fewer local government units. And the Pennsylvania Supreme Court threw out that map and sent it back to the legislature, to the Legislative Reapportionment Commission, and said, try again. They came back with another map. We sued again. We lost the second time. The new map split fewer local government units than the original map, but still we thought split too many. The Pennsylvania Supreme Court did not agree with us a second time, and by a 4-3 decision upheld that plan. Those are the standards that apply to state Senate and state House districts. The Pennsylvania Constitution says nothing about congressional districts. It gives no guidance to the state legislature as to what criteria it ought to use when drawing districts. So where do you look? You can look to federal law, both the U.S. Constitution and federal statutes, chiefly the Voting Rights Act. And they have some requirements that have been litigated a lot in the U.S. Supreme Court, some very recently. So one issue is the use of race in drawing district lines. And unsurprisingly, that's an issue that's been litigated a lot more often in southern states. It's been very rarely brought up in litigation in Pennsylvania. So there's as many problems as we have, there are certain problems that we should be grateful not to have. But just 2 days ago, the U.S. Supreme Court handed down the latest racial gerrymandering decision. And this upheld a lower court decision that had struck down a congressional plan in North Carolina on the grounds that North Carolina impermissibly used racial considerations in drawing its map. And what the court said essentially is that states must not, almost certainly must not consider race unless they are compelled to by the Voting Rights Act. And the idea here is that the Voting Rights Act is set up to ensure that the creation of what are called minority-majority districts. Districts where minority groups, either African Americans or Hispanics, are able to enact a representative of their choice, as opposed to being spread around from district to district such that every district is majority white, and no district will ever elect anybody else other than a white member of Congress. That hasn't been as predominant of a consideration in Pennsylvania, but it has been a big deal in North Carolina, to the extent that in North Carolina, after they lost that first case in the lower court, the state legislature passed a new map. And this was a legislature that was controlled by Republicans at a time when North Carolina also had a Republican governor. And they were very open about what they were doing, and in fact, the chairman of the North Carolina House of Representatives Redistricting Committee, and I want to read you this quote because I want to get it right. He said, on the floor of the legislature, I propose that we draw the maps to give a partisan advantage to 10 Republicans and 3 Democrats, because I do not believe it's possible to draw a map with 11 Republicans and 2 Democrats. So, that was the attitude in North Carolina. That, no, we're not doing this for racial reasons. We're just doing this because we want to stick it to that other party. In Pennsylvania, I don't think you could read the legislative record and find any statement made on the floor of the House or the Senate that was quite that bold. However, you ended up with a very similar result. You ended up with a map that we've seen here, 18 seats, 13 of them are Republican, 5 of them are Democratic, and that holds true no matter what happens in the statewide elections. In 2012, when Barack Obama won statewide by a big margin, 13-5. In 2014, Governor Wolf wins 55-45, 13-5. Last year, Donald Trump wins, 13-5. So this is a very durable divide that no shift, even if all the voters if large numbers of voters shift from Republican to Democrat and how they're choosing to vote in a given election, the members of Congress don't have to worry. They're insulated. They're safe. And that, you can decide for yourself what that means in terms of how responsive they feel to their constituents. So I just want to talk a little bit because a lot of people have asked, well, aren't you guys going to do anything about this in Pennsylvania? Aren't you going to do anything about our congressional plan? Yeah, we are. We are going to do something about it. I wish I could share with you exactly what we're going to do. You're going to have to stay tuned in the very near future to find out exactly what we're going to do, because lawyers like to be coy about things until they're publicly filed. And unfortunately, I have to be coy about it. But let me tell you a little bit about what's going on in some other states and litigation that will hopefully give you some ideas. In Wisconsin, a challenge was filed to the state legislative plan in Wisconsin on the grounds that the map was such an aggressive gerrymander to favor one party over the other. Wisconsin was the Republican Party also, that it crossed a line constitutionally. And this case went to trial. And it was the first time a case like this had even gone to trial in several decades. And the plaintiffs won. The lower court in the Wisconsin case said the map violated the U.S. Constitution. It's up on appeal right now to the U.S. Supreme Court. It's expected that the U.S. Supreme Court will issue a decision about 12 or 13 months from now. And it could be the first time a case like this results in a win in the U.S. Supreme Court, really ever. In North Carolina, there are 2 cases pending there about the partisan gerrymandering. And both of them also challenge, those cases are about the federal congressional districts, not the state legislative districts. And there's a case pending in Maryland where the shoe is on the other foot, where the Republicans were the ones on the receiving end of a gerrymander, and the Democrats who control the state legislature there drew the plan in a contorted, distorted way to disfavor Republicans. There are, I don't want to get too deep into math unless you guys want to talk about Markov chain Monte Carlo analysis, probably not. But there are a number of, it's a fruitful area right now in mathematics and political science. There are a lot of people who are really excited about these issues, who are coming up with all sorts of really creative standards that you can use, statistical measures, to look at a plan and gauge whether it crosses a line into the realm of unacceptability. And one of them that the Wisconsin plaintiffs use is what's called the efficiency gap. And when you look at Pennsylvania's congressional plan, we have the worst efficiency gap in the country. And the way the efficiency gap works is you look at how many votes are wasted in every election. And by wasted, what it means is in a race, say, a packed Democratic district, where 80% of the votes are for Democrats, then 30% of the Democratic votes were wasted because they were over and above what you needed to win. And 20% of the Republican votes were wasted because they didn't go for the winning candidate. So just by that simple kind of intuitive analysis, you just tally up the wasted votes on the Republican side and the Democratic side. And if it's a fair plan, you should expect the number of wasted votes to be at about the same level. You're going to have some races where the Republican wins by a little bit, and then a tight race, and some where the Democrat wins, and it's going to be a wash. You're going to have about the same numbers of wasted votes. But that's not what it looks like in Pennsylvania. In 2016, in the contested races, there were 15 contested races in 2016, the Democrats had 1.7 million wasted votes, and the Republicans had 700,000 wasted votes. And that created what, by their calculation, would be a 20.4% efficiency gap in Pennsylvania, by far and away the worst in the country. There are other ways you can look at it. Another is to compare votes to seats. In 2016, Pennsylvania Republicans got 51.7% of the votes in contested House races, 51.7% of the votes. But they won 13 out of 18 seats. That's 73.3% of the seats. So again, it looks bad because it is bad. And you know, Pennsylvania doesn't often get to brag about being #1 on something in the whole country, but there are a lot of these tests where Pennsylvania comes in #1. Some of them were #2 or #3. I don't think we ever get down to #4. But if there's one state that has bragging rights right now in the gerrymandering arena, we're #1. We are optimistic that the tide is turning, that courts have recognized that with the increasingly sophisticated analytical tools and data at the disposal of map makers, that this is getting out of hand, and that we can't let it float along like this for 450 years until we get to the situation of old Salem and Lancashire County, that there's going to be a solution sooner than that. And as I said, we're going to be having much more to say about that in the very near future. And I appreciate everybody's coming out here tonight to hear us talk about it. Thank you.